morning. First of all, I would like to thank you for giving me the possibility to introduce myself and briefly explain to you the legal regulations in terms of surrogacy arrangement in Georgia. My name is Nino Bogveradze. I'm a partner and attorney at the law firm Kurtadze Law Office. At the same time, I'm a professor at Georgian American University. I have been practicing law since 2002, and among other legal issues, I have been involved working on the surrogacy cases since 2013. I have defended my PhD thesis on the legal regulation problems of surrogacy and donation on international and local level. I have conducted my research on legal and ethical implications of gamete donation at Fordham University in the United States within the Fulbright grant awarded by the US government, and among other courses, I specifically studied the course of biomedical ethics at Harvard University. Since my time is limited, let me briefly explain you the legal regulations in terms of surrogacy arrangement in Georgia and the procedure itself. In Georgia, surrogacy arrangement is enforced through the administrative procedure after the birth of a child, where intended parents acquire the legal parentage over a child born in Georgia through such an arrangement if all the documents required under the laws of Georgia are filed to the Birth Registration Authority. We call it the Civil Registry. And if the Civil Registry issues the child's birth certificate listing intended parents as the parents of the child, there is no pre-parentage court order or a special committee approval or after-birth parentage or any other court order required or necessary to be obtained by intended parents for their recognition as the legal parents of a child and for listing them in the child's birth certificate. Civil Registry records intended parents as legal parents of the child born as a result of surrogacy arrangement if all the documents required under the law meet the law requirements and are filed in the Civil Registry within a specific time frame determined under the law. The court may be involved in this process only if the Civil Registry refuses to record intended parents as legal parents of the child, where the registry decides that the documents filed for the birth registration are not in compliance with the law. Most importantly, the result of listing intended parents on the child's birth certificate is that intended parents are provided with the full parental rights over a child without the need to obtain any parental custody or any other type of court order. Moreover, the law explicitly states that the donor or the surrogate mother shall not have the right to be recognized as the parent of the child born in Georgia as a result of surrogacy arrangement. In order for intended parents to be recorded as legal parents of the child born in Georgia as a result of surrogacy arrangement, there are specific requirements. One of the requirements is that the IVF, in vitro fertilization, may be performed either in an IVF clinic in Georgia or in an IVF clinic in any other country where such procedures are legal. However, in any case, embryo transfer procedure shall be performed only in a Georgian clinic, and the documents issued by each of these clinics, meaning the clinics in Georgia and the clinics in a foreign country, shall certify the performance of relevant procedures. IVF may be performed either with the use of the gametes of intended parents or of the donors. However, in terms of surrogacy arrangement, the donor may not be anonymous. Donors should be the party to the surrogacy and donation agreement and sign the agreement in the presence of a Georgian notary, either personally or through the donor's proxy, acting on the basis of a respective power of attorney. Only gestational surrogacy is allowed, meaning where the surrogate mother is on the gestational career and does not provide her own egg for fertilization. Traditional surrogacy in Georgia is prohibited. It's where the surrogate mother has a genetic link to the child. Surrogacy cannot be used by a single intended parent or same-sex couple. Intended parents must be heterosexual couple diagnosed with infertility and being in the registered marriage for at least a year or having lived together for at least a year. There are no requirements established for the surrogate mother to be eligible for the application of surrogacy. For example, surrogate mother's marital status or consent of surrogate mother's husband. Surrogacy agreement has to be entered between intended parents and the surrogate mother. If the donor's gamete has been or shall be used in the IVF process, surrogacy and donation agreement must be concluded between intended parents, a surrogate mother, and the donor. It is a mandatory requirement that either the surrogacy agreement or the surrogacy and donation agreement should be notarized by the Georgian notary. If the embryos created as a result of IVF shall be transferred to the surrogate mother's uterus without freezing the embryo, so-called fresh transfer procedure, the agreement shall be notarized prior to the embryo creation. However, if the IVF is already performed, the resulting embryos are frozen and the embryos should be transferred to a surrogate mother's uterus, the agreement should be notarized prior to embryo transfer. Since the laws of Georgia require the notarization of surrogacy agreement or the surrogacy and donation agreement, it means that the identity of every party to the agreement shall be revealed and it can be anonymous. The parties to the agreement have to either appear at the notary and sign the agreement in the presence of the Georgian notary, or the parties, either of them, excluding a surrogate mother, may be represented by a proxy on the basis of a respective power of attorney. No proof of the DNA test is required for the purposes of filing it in the civil registry. The documents issued by the clinics certifying the performance of the respective medical procedures are sufficient. The application to register intended parents as the parents of the child born as a result of surrogacy arrangement in Georgia should be filed in the civil registry by both intended parents within the specific time frame established under the law. And if the civil registry is provided with all the required documents within this time frame, the register will issue the birth certificate of a child listing intended parents in the birth certificate within 5 working days after the documents are filed. If the law requirements are not met and the civil registry refuses to register intended parents as the legal parents of the child born as a result of surrogacy, for example, if the surrogacy agreement has not been notarized by the Georgian notary, the donor is anonymous or has not been a party to the notarized agreement, etc., civil registry provides relevant information to the social service and the latter shall determine the name and surname of the child. In such case, the child's birth certificate is issued without indicating the parents of the child, and the child is granted with the Georgian citizenship. The full custody of the child legally is granted to the social service, and social service may take the decision to grant the temporary custody to intended parents, while the dispute concerning the recognition of intended parents as legal parents of the child is finally settled in the Georgian court. Of course, if intended parents apply to the Georgian court with this specific lawsuit. It should be underlined that the laws of Georgia prohibit any indication of a surrogate mother or the donor in the child's birth certificate, even in case the registry refuses to list intended parents in the birth certificate. Moreover, the law directly determines that surrogate mother and the donor are not entitled to claim parental rights over a child. The child born as a result of surrogacy arrangement in Georgia cannot be deported from Georgia if the child's birth certificate does not determine both legal parents of the child, even if the child has a foreign passport. So this is the general information on the legal requirements of surrogacy arrangements in Georgia. As a lawyer, I have been involved in these cases assisting the parties to meet the law requirements. In cooperation with an Irish solicitor, we can as well provide the services that is needed to meet the Irish law requirements for the exit process, specifically drafting and collecting all the necessary documents. I'm already involved assisting Irish intended parents in this process. We can as well involve and cooperate with an independent lawyer for a surrogate mother. Should you have any questions, please feel free to contact me. Thank you again for your time.